So, folks, as we head into Thanksgiving, it's really a reminder that our country was founded on the ironclad principle that everything we get, every blessing we're bestowed with, is from God. It's our adherence to Him and His law is really what allows us to deserve these blessings, and beseeching God to give us more blessing. Yet we now have in this country not just a political system that often works against the Bible and the Constitution, the biblical founding of the country, but we have this judicial supremacism, which, as I've always said, is a system we never adopted. It's really antithetical to the system we adopted, according the branch that is not elected with greater authority than even the elected branches have, power that the founders would have never vested in elected, much less unelected branches of government. And increasingly, as much as we feel that we're electing better judges, we're finding them hostile to our values and willing to issue novel rulings that shred the Constitution, shred the Bible, shred our history and tradition. And we're finding this from family court up to county, state judges, and obviously the federal judiciary, where, like we mentioned earlier today, we're seeing this everywhere. It just appears that for every step we go forward, appointing some better judges, getting some better rulings, but they always wind up being narrow. The left comes back, liberal judges do what they want, and we never really solve this problem. We're left with a system where fake rights that are antithetical to real rights, and in fact, infringe upon the real rights of other Americans, they're codified in the courts, they're elevated. Whereas, simple bodily autonomy in the realm of vaccine mandates, obviously, we have this big problem in family courts now, where when you have a divided country and you have half the country and certainly their legal elites believe that, for example, our religious beliefs, our social beliefs, our political beliefs, our medical decisions that we make, well, that's tantamount to child abuse. Okay. And therefore, they issue rulings in the context of family law, custody proceedings based on that. We have a very big problem. So, this is something we need: family law, family court reform. Recently, there was this crazy case in Maine you might have heard about, where a judge in Maine ruled, and it's now at the Maine Supreme Court, that a mother cannot send her child to church. And that really caught my eye. And I figured, you know what? Let's bring back our favorite conservative warrior in the courts, Mat Staver of Liberty Counsel, who has really been fighting all of the aforementioned cases, but is now one of the attorneys for the Bigford family in Maine. And he's with us today. Hey, Matt, welcome back today in this grim period of time.
Well, thank you, Daniel. Good to be with you. Yes, this case involving Emily Bickford and her 12-year-old, soon-to-be 13-year-old daughter, Ava, is outrageous. Liberty Counsel doesn't usually get involved in the typical domestic dispute case because there's a lot of different issues that don't intersect necessarily with religious freedom. But when we saw this order and we were asked to take the case over on appeal, we were compelled to get involved because the order is outrageous. I mean, every time it mentions the word God, it always lowercases God. And everyone knows what that means. If you have God as a capital G, you're referring to a supreme being, a specific supreme being. But if you have God as a lowercase g, it's like polytheism as opposed to monotheism. And when a judge does that, it's an absolute direct assault on, in this case, Emily Bickford's monotheistic views. She is mocking that by using the lowercase. And that's just one of many issues, including not allowing her to go to church or religious organizations. She couldn't attend any kind of religious event, no Christmas, no Easter, nothing. So it doesn't matter. She couldn't go to Hanukkah. She couldn't go to anything with regards to a religious event, anything that's involving religious philosophy, religious organization. She couldn't even attend a bell ringing incident for Christmas out in front of a mall for Salvation Army. She can't read the Bible. She can't be around religious literature. She has to disassociate from her friends that attend church, Calvary Chapel in Portland, that she's attended for nearly 4 years. So this is outrageous, and that's why we took the case over on appeal. I just argued it at the Maine Supreme Court, and we're now waiting on a result from the High Court of Maine.
So you're waiting on a result from the High Court of Maine. So obviously when you have a small g God, you have a big G government. So you have a judge that at the behest of the father, who is anti-religious, says that when the mother has custody over this child, Ava Bickford, you're saying it's not just an objection to that particular church. It's she cannot be exposed to any religious material, ceremony, practice.
That's right. Yeah, over 12 years ago, Emily Bickford Matthew Bradeen gave birth to Ava. She's now in January going to be 13, but they never got married. And so they, from the very beginning, had shared custody. Emily had primary custody and Matthew had visitation. Everything went well, so to speak, until May of 2021, when Emily and Ava began attending Calvary Chapel Church in Portland, Maine. And Ava wanted to get baptized. He went ballistic. And he is obviously an atheist. He hates God. And so he ran to court and he found a judge who was willing to go along with this anti-religious rant regarding churches. And so he brought in a so-called expert from California, a Marxist former sociology professor, who talked about the so-called Moses model, as though Moses is a bad example. You know, for Jews and Christians, Moses is a good example, a very strong leader, charismatic leader who brought the children of Israel out of Egypt into the promised land. But this individual said, well, they follow the Moses model because the pastor teaches from the Bible verse by verse, chapter by chapter, so that's a bad thing. And by teaching verse by verse, chapter by chapter, oh my goodness, you're going to be talking about angels and demons and heaven and hell. You'll be talking about all these things. Well, although there's no evidence, she says, that there's been any harm to Ava from any teaching related to the Bible, well, there could be psychological harm because these things could psychologically harm a child. So consequently, taking all discretion, all decision away from the mom after 12 and almost 13 years of Ava's life and putting it into the hands of this atheistic father who not only vetoes her right to go to Calvary Chapel, but her right to go to any church, anywhere, including any religious organization, any religious philosophy, any religious literature, video, including the Bible. She can't read it. So since December of 2024, when this order's been entered, she's not been able to go to any church, any religious event. She's not been able to be part of a Bible study. She had to disassociate with her friends that she had made at this church for almost 4 years. This is an outrageous order. And anyone thinking that it would be permissible to put this in print is unbelievable. So, you know, we have this issue with federal judges, as we've seen with the Trump administration being against the buzzsaw of some federal judges, but this is a state court. And so now we're in state court. We're raising the First Amendment. We hope we get a correct decision from the Maine Supreme Court, but if we don't, the next step will be the U.S. Supreme Court. Hopefully we don't have to go that route, but that's certainly in the mix if we have to do so.
So one of the things that I've been concerned about, and it really came to life during COVID, is in these family courts, these judges have a lot of power. And this is a case where the parents are not on the same side, but we have even where they're married, they're on the same side, where you have child protective services. That's another angle of family court where, you know, someone could snitch in the education field, a teacher or a nurse in the healthcare field, and say, I don't like the decisions they're making, you know, educationally, medically. This came in a lot with vaccines. And it's still a problem. And again, religious views, social views, political views. The left believes that our views are abuse.
Yeah.
Right? I mean, that's what they believe. So this is a big problem in the family courts. What are the sorts of things we need to be looking at as we enter the legislative sessions for January in most state legislatures to reform the power of these judges and just the proceedings of family court?
Well, it's definitely an issue, and it also includes the so-called LGBTQ agenda. And in fact, that was an issue here. They said because the church teaches, male and female marriage between a man and a woman, it's, quote, homophobic. So, when you have a child that's confused regarding who they are, and now they want to identify as something that God did not make them to be, the opposite or something else, and you say, no, we're going to adhere to reality. Let's deal with what it is that's causing you this kind of mental stress rather than mutilating your body. Then you run to a court and the Child Protective Services says, this is child abuse because they're not affirming that child. That's an issue. So I just spoke to over 400 people. Most of them are, virtually every one of them were state legislators from 35 states talking about this specific issue. We had 20 different points of policy, and one of them was parental rights and religious freedom, talking about what the state legislators need to do. We provided policy recommendations, including state legislation, to strengthen religious freedom, to strengthen the rights of parents so that, we can be prepared and have laws that stop these activist courts or even activist child protective services agencies in some of these states. So we have a policy briefing that we've done to many different legislators. We're going to continue to roll this out, speaking to a lot of legislators across the nation to provide draft policies. In fact, while I was speaking, some legislators from Ohio came to me and said that the state Senate in Ohio already passed a law that would really hurt parental rights in the very issues that we're talking about, Daniel. And so we were talking with some of the state House members about how to resist that, because now the next step is a vote in the state House in Ohio. You wouldn't think that this would happen in Ohio. Maybe New York, maybe California.
Republicans have a supermajority in the legislature there.
That's right. Yeah. And it's already come through, past the Senate in Ohio. So we have to be vigilant in all of these states to protect religious freedom, especially to protect parental rights, because that is becoming an object of attack.
It's funny because I doubt you would have a case like this Maine ruling with Bigford in the context of Islam and Sharia law. Could you imagine that, by the way, if a judge would have said, you can't attend a mosque or, anything to do with the Quran? Somehow I just don't believe we would have seen a ruling like that.
No, I think what you would have is a huge public outcry, and I don't think you'd have any judge that would want to even, try to do that. But, if it's Judaism or Christianity, so for Jews or Christians, you're open season. And that's, in fact, I think what we're seeing here. And that's what we have here. We have a judge who listened to this so-called expert and just adopted it verbatim, basically, and used the same kind of derogatory thing, not only in terms of this breadth of the order that basically is no religion, period, zero. And then, by the way, the religion that you hold, monotheism, we're going to mock it by using the lowercase God throughout.
So I think this is a good segue into the next point that, look, and I know it's tough for you to say this as a practicing lawyer, up and down the, different layers of state and federal court, but a lot of judges, we all know there is no uniform jurisprudence, that it's very much outcomes based. Like we just noted, they do look at the politics of it. There's no question. And there's no question you wouldn't have a ruling like this with Islam. So Kim Davis, I mean, we talked about this earlier in the year with much anticipation, that this is not just an old case regarding gay marriage, but this is a woman who is still on the hook being sued for so-called emotional damages for not having had her name on the license, even though this so-called couple had their license granted to them. So it went up to the Supreme Court. They denied cert. And I look at that, Matt, and I think, again, let's just put religion and politics aside for a minute. Just in terms of jurisprudence, we all know that we had a majority on the Supreme Court behind the Dobbs opinion. And the Dobbs opinion reaffirmed that in order to enshrine an unenumerated right, you need, and that would mean that a state cannot regulate beyond that. In this case, say marriage is the way it always was, is it has to be deeply rooted in history and tradition. Now, we all know that abortion was a lot more rooted than gay marriage, which didn't come until last generation. And yet they rule on Dobbs and just ignore this. We all know there's no deep-rooted legal theory behind that dichotomy. It's political.
Yeah. Yeah, you're right. Even the retired liberal Justice Stevens wrote a law review article, which we actually cited and quoted in our reply brief asking the court to take the case. And he said, using the so-called substantive due process, which essentially says if it's not enumerated, then it has to be deeply rooted in our history, such that you need to protect it. And if you don't, it will result in the undoing of ordered liberty. So it has to be deeply rooted in our history. He says that Obergefell does not fit that pattern. And he's right. Obviously, not only same-sex marriage was not rooted in our history, but for many years, sodomy had been criminalized up until the U.S. Supreme Court changed the rule on that and overturned a previous decision that they had decided. So it's clearly not rooted in our history. We know that 3 of the justices, the Chief Justice, Thomas, and Alito, have written strong opinions in opposition to Obergefell. Chief Justice John Roberts was so strong against it, he actually read his dissent from the bench in 2015. He never did that before. He's never done it since. He did that to emphasize his opposition. And he referred to his colleagues as 5 lawyers, imposed their opinion, not a legal judgment. And their opinion had nothing to do with the Constitution. So we know 3 of them are very strong against it. All we needed is 1 more to take the case, and obviously we needed 2 more to win. The fact that the Supreme Court justices did not take the case is very concerning, heartbreaking, frankly, not only for Kim Davis, but for this issue. Still, Obergefell is the Supreme Court's opinion. I believe it's not a matter of if, it's just a matter of when Obergefell will be overturned. It will be overturned, no question about it.
But how?
Well, I think it'll be another case kind of like Kim Davis, or it'll be a case where legislators just say, you know what, we're reasserting our 10th Amendment right. There are 30-some state constitutions. Florida, where I live, is one of those that still have the constitutional amendment in the state constitution that says marriage is the union of man and a woman. Those have not been repealed. And in addition to that, there's many other states that still have their marriage laws. So you have about 40-some states with marriage laws that still exist, man and woman as one in marriage. So, you had a state in, for example, the Dobbs case that took on Roe by passing a law, 15-week abortion ban. They knew that would not fly under Roe, so they went directly against it. You don't need to pass laws. You just need to reassert your authority under the current laws. And that would have a clash. And, there's other states, Kim Davis and the clerks in Kentucky are protected, and their names are off the licenses now because of Kim Davis. In Texas, just a few weeks ago, the Texas Supreme Court, 9-0, protected the state court judges, saying that they have a religious freedom right to opt out of same-sex ceremonies. And they said Obergefell does not predate the First Amendment. The First Amendment predates Obergefell, and it can't override the First Amendment. So Texas is protected, but a lot of states are not. So I think this clash could happen again. The fact of the matter is, however, it shouldn't have to. Kim Davis had a very good fact pattern. We had 2 of the 3 questions presented that were on religious free exercise. They should have taken at least those 2. The third one was overruling Obergefell. Now that they're not doing it, not taking the case, we have to deal with the fallout with regards to Kim Davis now, because she's personally still on the hook for something that she got an accommodation for in 3 ways. They got their license, she got the accommodation, but they said they have hurt feelings and they want money. And unfortunately, that's what we're having to deal with now in the final phase of this case. But it won't be Kim Davis's name attached, but Kim Davis, her legacy, I think, will inspire others, and it will be the foundation on which we build the overturning of Obergefell. It will happen, and we're working towards that ultimate objective.
No, and I think it's important to note that, again, you have to fight politics with politics. It's not a matter of, there's no legal argument that you could have given that would have gotten this result, just because it's a matter of the political magnitude of it. I'm not defending the judges, but I think we've seen this pattern. To your point, when the state legislatures made a concerted effort to say, you know what, we're done with Roe. We're done with it. We're going to pass laws in concert with what we know to be true. And you saw that beginning with Mississippi, and that built the political momentum, because the political and the legal, you cannot separate them. That's just the reality. And I think, like you're saying, the states are going to have to gradually move into this, what makes sense politically to do in each respective state, to start pushing back against it and building that momentum and forcing the issue. We cannot let this go. And, you know, it's funny, Judge Posner of the Seventh Circuit said it was public opinion. He said openly they waited for public opinion to push gay marriage. And I think now the public opinion is ebbing, because now 10 years later, people see this was not just about a piece of paper. It was about fundamentally altering what gender is, because that's really what gay marriage is doing.
That's exactly right. In fact, if you look at the policy coming out of Obergefell, what it says as a policy matter is what we're experiencing today with the whole LGBTQ issue, men and women's sports, invading private spaces of women. And that is, in a gender-based relationship of marriage, it's an obviously gender-based relationship. Obergefell says gender doesn't matter. Well, if it doesn't matter in an objective gender-based relationship, then it doesn't matter anyplace. So it is the root of all the LGBTQ agenda. And I think the more we have people understand the problem with Obergefell, the better. But I think you're right. Politics may have to drive this more. And one way to do it is to have the states just simply say, enough is enough. You know, the judges have to be careful, because even in the 1992 Casey decision that upheld Roe, they did it for political reasons. Why? Because they said the people, even if they had made a bad decision in 73, which they did, even if they made a bad decision, the people had relied upon that bad decision. And if they change course, the people will lose confidence in the judges. And the only power that the courts have is that the people respect it and give it its authority.
Bingo.
But when the people lose respect for the judiciary, then they have no power, because they don't have the ability to even enforce their own orders. What they write is something on a piece of paper, and who enforces it? It's not the courts, it's the executive branch. And if the executive branch refuses to do so, then it's just a piece of paper. So the courts and judges need to be careful. If they overplay their hand, they will ultimately lose the confidence and the respect of the people, and thus lose their ability to be judges and be courts. Because the people will say, enough is enough. We need to follow the rule of law, and you're not, and we didn't make you a king.
Well, I'm still waiting for that to happen. I mean, it's pretty remarkable with what you're seeing going on in the courts. And I have this debate even with conservative legal scholars and other, you know, just conservative lawyers, that they're so bought into this notion that there's a food chain, and one branch, and particularly the unelected, with the comparatively weakest branch, according to Madison, which is why they're not elected, stands atop the food chain. And it makes no sense, because a lot of people are focused, for example, with the Trump administration. We've seen this whole torrent of rulings on a myriad of issues over the past year. So they focus, oh, he's doing things executively. Okay, but here's the problem. Now we're starting to see with the budget reconciliation bill, they passed through the whole legislative process, defunding of Planned Parenthood. So that was statute signed into law. Judge says, no, unconstitutional. Then you had just over the weekend, I mean, I know the guy who authored the bill, IRA, the 1996 immigration law, provides for expedited removal of those who haven't been here for 2 years. And it said the courts cannot review any cases to create an actionable case against that, or to assert a right that you've been here 2 years or whatever. And a DC district judge just says, screw that, I'm doing what I want here. And then a 2-1 opinion of the appellate court upheld that. So my point is, you can't legislate your way out of a problem if you believe that whatever a judge says, he gets to determine who has standing and who doesn't. What is the case or controversy? He gets to determine the boundaries of his power and the other branch's powers. He could determine executive action, statute, constitutionality with finality, and he doesn't stand for election. Matt, I don't understand. The founders were that stupid and thought of a system that was worse than King George?
You know, Daniel, you're right on. And I think this is the problem that we're seeing very clearly with what the judges are doing to the Trump administration and to President Donald Trump. You know, they're getting reversed very frequently, particularly at the U.S. Supreme Court. But the Trump administration, Donald Trump, shouldn't have to constantly run with emergency orders all the way up to the United States Supreme Court. But these judges are taking cases that they know they have no jurisdiction over. For example, you know, they started off taking a case that would be maybe some association, some entity, or an individual. And then they would give rulings that would be not only nationally, but even globally, trying to even affect people that are outside of American territory. They know they don't have a case for that. They don't have jurisdiction to do that. That's exactly what I'm talking about. The more judges act outside of their judicial role, which is a limited role, then the less they will ultimately have power, because the people will disrespect that. And their only authority is that the people respect it, and they voluntarily give respect and authentication to their orders through the other branches, particularly the executive branch. And if the executive branch gets fed up with it, I mean, this is the battle that we had with Thomas Jefferson. You know, Thomas Jefferson says, as he's writing in one of his letters, you seem to think that the judges have all this power. They don't. They're the weakest branch. They're supposed to be the weakest branch. That's why they didn't have a specific building until the the early 1930s, 1935 or 1937, when the Supreme Court was built. They were meeting in the basement of the legislative branches in Washington, D.C. And it's because they didn't have that kind of authority. They've usurped it over time. And Big Brother essentially has been a bad example for its other siblings, if you will. And so the Supreme Court of the 60s, 70s, particularly in its very liberal 80s, and then kind of turning the quarter 80s, 90s, and 2000s, they set a bad example, became very activist. So what that did was that affected the law schools, because that's what law school students learned, was Supreme Court opinions, and they didn't learn the Constitution. They didn't learn proper jurisprudence. They go out there and they're the ones that are the judges and the justices on the state courts, and they feel, well, if the Supreme Court got away with it, we'll do the same thing. And so we're having a change that's happening at the United States Supreme Court that's becoming more originalist, but now it has to catch up in the lower courts as well, and certainly in law schools. And that's why back in the late 90s and early 2000s, I teamed up with Dr. Jerry Falwell. He had a vision to start a law school in 1971. My vision started in the 1990s, litigating in cases and realizing, you know what, we have to train a whole new generation in what the law is, respecting for the rule of law, because otherwise we're doomed. We get all these cases, we pass all these laws, we litigate, but then we get judges who really don't care what the law is. That's the problem.
They don't care. It does not matter what argument you make. And this is the problem with the game of catch me if you can. On paper, the Supreme Court has gotten more originalist, but again, they only take of a small amount of cases. It's very political, and the lower courts just do what they want. So it's like, I predict this on my show with the Alien Enemies Act. On paper, that was a huge victory for the Trump administration. But again, I'm telling you, the lower courts are going to come back and make them litigate each case. Well, prove to me with the preponderance of evidence that that guy's a gang member.
Yeah, that's right. You know, like in 2020, when the COVID lockdowns came down on places of worship, we litigated. We lost in the district court on an Obama-appointed judge in California, lost 2-1 in the Court of Appeals for the Ninth Circuit, went to the Supreme Court December of 2020. We won 5-4, went back down to the lower court. should have been a no-brainer, lost again, went to the Court of Appeals, lost again, went back to the United States Supreme Court in February of 2021. This time we won 6-3, striking down all these lockdown restrictions on churches and places of worship in California. But we shouldn't have had to go back to the Supreme Court twice. They didn't care what the Supreme Court said. It's exactly what you say, and they know, they might get reversed, but the chances of it are minuscule because they know that the Supreme Court only takes maybe 60 to 70, maybe up to 80 cases, 1% or less per year. So most cases, no matter how bad they are, the Supreme Court is not going to review those cases. They're not going to accept them. So they're going to stay in the lower courts.
No, and then what's worse than that is even where you get a reversal, they play this game. Well, okay, every case is slightly different. So you come back with a new case, they'll restart the clock. And unlike for conservative lower court judges, because they own the law schools, because they own the legal profession, there's no stigma to doing what they're doing and playing that game of catch me if you can. And they'll just run up right against the Supreme Court precedent, but they'll say it's a slightly different case and you'll have to wait on that again. And I just think that at some point on the right, we're going to need to update our strategy. And that does begin by at least a recognition that whatever you politically want to do with it and when you want to do it, in what case, judicial supremacism is a legal fiction. That over issues affecting the whole of the people, we're not talking about a criminal conviction of an individual, but like what we're talking about, these sorts of broad-based issues, what's a woman, what's a marriage, they do not determine that with finality, and the other branches do need to start pushing back. Where could people follow your work and be abreast to some of these cases so they can go and potentially help your organization?
Well, Daniel, they can go to Liberty Counsel's website. It's very simple, just two letters. Two letters would be lc.org for Liberty Counsel, lc.org. And right there on the top of lc.org, our webpage, there's a lot of different tabs. You can sign up for direct mail or email. That'll keep you involved. Particularly the email will keep you up to date with a lot of issues that affect our faith and freedom across the country. Not only what's going on, but how you can make a difference. So the website again is lc.org, lc.org.
lc.org. Matt, thanks so much for fighting the good fight. May God bless you and your organization. And thank you all for listening. Until tomorrow, we'll see you back here. Same time, same place. Micah 6-8.